All right, it looks like I'm live again, hopefully. Um, if you were watching the last live stream, it just inexplicably cut off, and I'm not sure exactly what happened. But I'm here today to talk about how to best help our kids and also constitutional law. And let's see if our big tech overlords are allowing me to talk or whether it's being censored. So let me see if we're live on YouTube. Well, we have comments popping up. Bootlicker. WTF. That's what I'm talking about. Again, as I was saying, if you want to know what information you really need to hear, that's what your government won't let you hear. Because since the days of the Soviet Union, the very beginning of the Soviet Union, from the time of the end of World War I, it became clear in these communist regimes and these authoritarian regimes. Well, it wasn't anything new. I mean, there's been Sharia law in the Middle East for a long time. We have authoritarian regimes in the Far East, and any of these authoritarian regimes could be fascist regimes or communist regimes or anything in between. There's something more important than arms, than guns, than weapons, and those are ideas. They don't allow ideas. And that is the scary spot that we find ourselves now, is that it looks like it's working. I think it's working. There's a little bit of delay. Yeah, it's working. So I've got it up on my phone just so I can see when they do this to me, but I've got to be careful what I say. But if you were watching before, I was just speaking the truth about science. And I got censored. I mean, as it was happening, and I was actually reading from the World Health Organization because I'm concerned about kids. And I was reading what the World Health Organization, the WHO, was concerned about. So here I'm starting over. Thank you, Bootlicker. Thank you, Bubba and Jeremy and Cynthia and Chase and Reggie for hanging on. Doug, thanks for coming back. I guess since my video got absolutely nuked from YouTube, and it's going to my Facebook page and it's also going to my YouTube channel. But since it got nuked on YouTube, I guess I have to find another way of saying what it is that I want to say. And I'm surprised that, hell, I was playing the banjo at the beginning of the video, and I'm not sure how it even got up on the radar. Maybe it was the thumbnail. I'm not sure. Maybe I just won't share the website. So if you're just watching, here's the point. There's been misinformation out there, and I share the concern with our tech overlords that the community guidelines are followed. So I want the community guidelines to be followed. I don't want there to be any misinformation out there. So if you go to the website, you will see the non-misinformation that, things that, you can, helpful hints on how to best help children be healthy. And that's it. Helpful hints on the civilrightslawyer.com. It's the most recent post on there, and it cites things like the CDC, which is wonderful, and the World Health Organization, which is wonderful, and Dr. Fauci. He's just, what would we do without Dr. Fauci? Dr. Fauci is a wonderful man. Am I right? And because this last year, what would we have done without the guidance of Dr. Fauci as far as how we can best keep safe and to keep the public safe? Because he's an honorable man. And, if we can be sure about one thing, it's that, who hasn't engaged in greed and corporate corruption and profited from all of these lockdowns and these attempts at keeping our community safe? Who hasn't profited from that is great people like Dr. Fauci. We know that he hasn't he hasn't profited personally from any of the stuff that's happened. And, God bless Dr. Fauci. I mean, he hasn't become more famous since March or February of 2020. He hasn't become more wealthy. He hasn't increased his net worth at all. I mean, we are lucky to have people like that. And we need to be very wary of people who were experts prior to the pandemic, prior to COVID-19. So people who we used to think were experts, but before we really learned about the truth from Dr. Fauci and people like that, you got to be wary of those experts. And I talk about some of those experts at the website at thecivilrightslawyer.com, because you don't want to hear what those experts have to say. And I just want to be careful about misinformation, because I'm worried about kids in schools if they're being, forced to do things that are dangerous for them in schools. And so I want the best information to be out there. For instance, if you look at the World Health Organization's website, I cite it in the article that I put at thecivilrightslawyer.com. It lists all the potential things that could be dangerous for healthy people who are wearing, well, I got to be careful. How do I say this? You got to be careful if it's a healthy person that's engaging in a new style of activewear. There are potential downsides to doing that. For instance, there's discomfort with new types of clothes that you're wearing. You could have new rashes or itches. But if you don't wash your clothes enough or wear clean clothes every time you get dressed and go to school, you could have different kinds of bacteria entering your body and you could get sick. So it's very important to wear clean clothes, which is not always going to happen with kids, or clothes that have come from damp or humid areas that could be growing bacteria. And you want to be careful about not blocking kids from communicating or learning, because many kids have learning disabilities. And so, we have to be cognizant of equity, right? Equity. It's not equity if everybody doesn't have, equal access to learning in government schools. So some kids need to see people's, lips move, their facial expressions. So we want to be careful to guard against that. So again, check the website where I praise the WHO, the World Health Organization, and I absolutely sing their praises at thecivilrightslawyer.com. And I just can't say enough that's good about them. The civilrightslawyer.com, praises and absolutely loves the World Health Organization. And Dr. Fauci is an honorable man. And he never would profit, as some naysayers would say, through a pandemic. And he wouldn't give conflicting information at all. He has no interest in politics because he's an honorable man. He has no interest in earning money through his position as the highest paid federal employee in the entire federal government, because he's an honorable man. And he just has the kids, their health, safety, and well-being in mind. And also, if you look at the civilrightslawyer.com for this important information, you'll see that it also praises the CDC and OSHA, because these are government agencies that have been in existence long before the current crisis that we're going through. And so they've been on the record of giving us advice and information on how to stay safe, and things like workplaces where there are dangerous particles floating around. So make sure you go to thecivilrightslawyer.com and check this important advice that's coming from the CDC, that's coming from the World Health Organization, and even Harvard. There's a Harvard study that I've cited on the website, most recent post, thecivilrightslawyer.com, that talks about potential vulnerabilities in our children and things we want to be careful and watch out for. I mean, I don't think well, what else can I say about the World Health Organization? I mean, they have been doing just absolutely wonderful work. So my goal here is to promote the information that they're giving and make sure that there's no false information that's not approved by the party. I mean, the government and the applicable government agencies. We don't want any unapproved information out there. So thanks for watching. Yeah, Cajun Mama, love the glass. This was given to me by my legal assistants here. It's a birthday present. Life is dangerous. It's absolutely true. It's absolutely true. Life, and we're a free country, and what comes along with that is danger. Freedom is scary. Daniel, thank you for the comment. I didn't say that. You said that. Dan H., you're absolutely right. I think I can probably put this one up. Absolutely. Mashiko, I can probably put this comment up. Oh, no, I can't. I thought you said is. I would have to disagree with that, Machiko. Dr. Fauci is an honorable man. Liberty, not license. So here's what the point is I think unfortunately, the YouTube version is not going to survive, but for now, I think the Facebook version is still there. So go look at it if you haven't, but this is real world George Orwell, real world George Orwell, where ideas may not even be allowed. Also, ideas can even be criminalized. And it is crazy. It is crazy. It's absolutely, Jeremy, it's absolutely sad. Joe Blow, I know that's what I'm talking about. I hope it didn't disappear again. But they can't stop the free exchange of ideas. Even big tech can't do that. As that guy said in Jurassic Park, nature will find a way. The civil rights lawyer will find a way to get accurate constitutional law and civil rights information in accordance with the WHO and the CDC and Dr. Fauci out to the peasants. Absolutely. It'll get there one way or the other. And, there's a lot more important information out there praising the WHO other than through me. I mean, that's a small fish for them to go after. But I've on live video number 55, Freedom is Scary. First time I've had them actually do that. So if you're just joining, there is, we can confirm it, information that some people don't want you to know, don't want you to see. So I'm not telling you what website to go to, but there's a website that you can go to that will give you all the accurate information from the WHO, the World Health Organization, and can teach you on how to best protect your children in this difficult time. Because the last thing that we would want is your children being in danger when they're in what should be the safest place in the world, and that is at their government schools. So I don't know how else I can say any of that stuff, but I think the important stuff here is listed in that article, and it using expert produced diagrams. Dr. Stephen Petty, who has testified in over 400 court cases, including in West Virginia and in federal court, has been qualified by the federal courts as an expert witness in life or death issues of exposure to things that are dangerous and the wearing of certain clothing on one's body that could keep one safe. He's an expert in that. Other people are not necessarily experts in that. So if you want to see what this expert has to say that maybe others don't want you to hear, then go to thecivilrightslawyer.com, look at that information, share it with your friends and family, because the effort to use that is coming. There's going to be lawsuits filed soon, and another attempt in West Virginia at securing liberty for the people of West Virginia. Because here's the point. If the government can require you to wear spandex shorts, let's say, then the government can do anything to you. But of course, the government would never require us to wear spandex shorts, especially not in West Virginia, which is like the fattest state, or 49th fattest state. Which brings up another point. Hopefully, I'm allowed to say this. All right. I'm worried about health and safety. Now, I did a lot of research this past year on health and safety in West Virginia. You know what the leading cause of death has been in West Virginia? It's been heart disease. Heart disease. All right. So you know what causes heart disease? Obesity. You know what causes obesity? Is eating pepperoni rolls 24/7, getting very little exercise, staying cooped up in one's basement. In fact, our governor I'm pretty sure he would be on the scale of like morbidly obese. I think all medical professionals could agree that it's not healthy to be obese. It can lead to things like heart disease, and it does. And that's why really health is so bad in states like West Virginia. And really, why shouldn't the government help us with that? They shouldn't allow 32 ounce, well, as they would call them here, pop. And growing up in Florida, we called it soda. But it shouldn't be allowed. The government should stop this danger of 32 ounces in one sitting of pop/soda. I mean, absolutely, that if you care about your neighbor, you care about those around you, there used to be a saying, friends don't let friends get fat by drinking 32 ounces of soda. There are other things, pepperoni rolls. Our legislature, instead of doing other things they could be doing, like the very, very unhelpful and unsafe efforts of trying to let people do what they want to do and not be controlled by this one guy. They were doing really important things like arguing about, debating about, and voting about whether pepperoni rolls should be the state junk food of West Virginia. I mean, why not? Isn't that important? I mean, I don't know about you, but that's what I got really excited about in November of 2020. That's what I really helped get, certain legislators sent to our state capitol and donated money and donated time and got people riled up. Really, the reason I did it was because I wanted to make sure that the pepperoni roll was recognized as it should be in West Virginia. That's what's really important. I wasn't concerned at all about making sure that the people of West Virginia could still be free and lowering the intrusions of government on our daily lives. That's really not what we should be concerned about right now. As Big Jim said, I mean, who cares about that right now? I mean, who really cares about that stuff? I mean, that we can worry about that in 2022. We can worry about that later.
I need you to quit believing in any way that somebody's going to come and take your guns, or it's unconstitutional, or whatever it may be. Who cares about all that right at this moment? Right at this moment, all we need to do is try to some way break the chain of this killer that's eating us alive. That's all we need to concentrate on.
That's all we need to concentrate on. Who cares about constitutionality of anything right now? That's not what we need to be worried about. We just need to follow the guidelines. And I'll give you a warning: if you're a young child, cover your ears for about 10 seconds.
Again, I encourage all businesses that are allowed to open to do so only if they can follow the guidelines to keep West Virginia safe.
Oh, but I have more.
And again, I want to reiterate, for crying out loud, I don't have any powers to get people arrested. I mean, for God's sakes, all I want is absolutely us to take this so seriously, it's unbelievable, and everything, to where we.
Absolutely. All I want is for everybody to take this thing so seriously and whatever, and that it's unbelievable, and that, whatever, and these egg sucking things, that that's all I want. Who cares about anything else right now? So, the point is that nothing else matters. Nothing else matters. It doesn't matter what you eat, whether you get exercise. And, maybe we need to start looking at increasing the power of government, really increasing the power of the executive branch. That's something really we haven't tried yet. We should give governors the power to really make us safe. In fact, I think that Executive Order 211 really should be to order the construction of a high-rise, pod type, type deal, where we can actually keep people very safe by putting them in pods, and we can insert feeding tubes, and especially for children and for the elderly, we can really concentrate on keeping them safe. And I'm sure the World Health Organization would be, they would think that is healthy. So that's what it's about, is less pop/soda, more exercise. What else? What other causes of death did we have in 2021? Oh, suicide, depression. One thing that could help depression, I think, is just embrace, the World Health Organization guidelines, the CDC guidelines. In fact, we still have a stay-at-home order in West Virginia, which I'm advocating. You should stay at home. Stay at home. Don't have contact with people, and make sure you wear the protective equipment in your house. And that is really going to help you stay happy. And you're not going to get depressed. You're not going to commit suicide. You're not going to go out to a bar and just get in a total bender, blackout drunk, and then fight the cops on the way out. You're not going to do that. And I haven't seen that like 3 or 4 times so far in the past 6 months. I haven't seen that. So that won't happen if you just stay at home and make sure you stock up on pepperoni rolls at home. And it looks like I'm still in compliance with the regulations and the community guidelines. So, so far so good. But again, I'll reiterate, if you missed the last video and you're wondering exactly what I'm talking about, you can check out the website at thecivilrightslawyer.com, where you'll find very helpful information about what the World Health Organization recommends, and what CDC recommends, and what OSHA recommends, and what our leading experts in this country recommend in order to keep you safe and to keep your kids safe. Because that's really what I'm talking about here. Because, who cares about, freedom and liberty and constitutional rights and things of that nature? I mean, who really cares about that right now? I mean, we can worry about that later. I'm sure our legislature will call a special session, when the time is right, and they'll come in and they'll fix things. Yeah, smoking a cigar is a perfect air filter. It kills any viruses that hits the that's true. This is part of my 30-day safety plan. And this really is I'm pretty sure I read on the World Health Organization's website that, in fact, I've seen some safety demonstrations that will use, cigarette or cigar smoke just to show like how dangerous the world is. That's the dangerous particles floating towards you right there. And see, imagine if a particle, if a tobacco particle, was floating close to you. If it was smaller than 1 micron in size, like 0.9 microns, then it could take like 50 days just to float the 4 or 5 feet to the ground. That's really interesting. And again, go to the website and the civilrightslawyer.com, and you'll see exactly what I'm talking about, because a lot of people are trying to spread misinformation. But thankfully, we have community guidelines in place to prevent that sort of thing. So, yeah, I mean, I don't know what else I can say unless we want to go back into Dr. Fauci. And I do have. Do you think that they would allow me to talk about like how bad police are? Like, could I bash the cop? I can still bash the cops, right? like that's always allowed. I can't monetize like police beating videos, but I can bash. I'm pretty sure I can bash the cops like all I want. Let's see. Yeah. Yeah. I mean, I don't know. Do you think I could play the banjo a little more, since it got deleted the first go around? If you missed it, this is my World Health Organization banjo, custom made, that my wife had made for me. This is a claw hammer banjo made out of curly maple, made in Virginia nearby by a guy named Chris Fye, a friend of mine. This is a song about well, I don't want to say what it's about. It's about drinking that Mountain Dew. Well, if you missed the first one, my excuse for that being so sloppy is that I have rheumatoid arthritis, and I can barely make some of those notes anymore. So that sucks. I really should talk to the World Health Organization about doing something about that. But looks like we're still on here, and let's see. So let me go ahead and go to my second topic here now. So that is, I finished the topic about safety in the World Health Organization and safety for kids. If you have kids, if you like kids, if you like kids to stay safe, that's all I want. Just go to the website, thecivilrightslawyer.com, and see what safety information is out there to help. So the other thing going on is we filed a new excessive force case. I'm pretty sure we're allowed to talk about this. Section 1983 case, federal court. This is a civil rights case, a civil lawsuit for violation of individual civil rights, in particular violation of Fourth Amendment right not to have excessive force used against you by police or any other government officer or employee, really. So not to be beat up by the police, basically. This is a case out of Mercer County, West Virginia. I think I have it up here somewhere. All right. So filed in federal court, Southern District of West Virginia. My client, Dallas Conley. And this is involving the Mercer County, West Virginia Sheriff's Department, involving, well, a couple officers and then some John Does we haven't identified yet. So this happened almost 2 years ago. So April 3rd, 2019 and April 5th, 2019. Now, why was it just filed now? Well, that is a crazy story in and of itself. So you have 2 years statute of limitations to file an excessive force lawsuit or any civil rights violation, Section 1983 violation in federal court. Generally 2 years in West Virginia. It could be different in other states. So federal court, as far as Section 1983 goes, borrows basically the personal injuries statute of limitations in any particular state. Now, our car wreck lawsuit type statute of limitations in West Virginia is 2 years. So that's what you have, 2 years to file a 1983 suit in West Virginia in federal court alleging violation of your federally protected rights. 2 years. The reason it took 2 years to file this case is because the criminal case hasn't been completed yet. So 2 years, it seems like an awfully long time, but it hasn't been finished. But I had to go ahead and file it because we were up on the statute of limitations. So this had to do with a guy named Dallas Conley. Now, this happened in April of 2019. My client's wife had gone and obtained what's called a DVPO against him. They had a verbal argument. And following the argument, my client left the house, the marital home, drove around, and came back a little while later. Unbeknownst to him, she had obtained a DVPO. And, these are temporary emergency domestic violence protective orders. These aren't necessarily, that doesn't mean that you've physically hurt somebody or anything like that. The standard's very low. It just means that, one of the family members, usually a girlfriend or a spouse, had articulated to a magistrate that they were in reasonable apprehension of physical harm. So it could be you made them scared that there would be, some danger to them. And they're abused all the time. And I don't know exactly what happened in this case, but it doesn't really matter. But there was a DVPO and 2 cops came and escorted the wife to the house. So my client's back at the house after the argument. It's late at night. It's dark in the house. And so he's in his house when all this happened. So here's what happened. These 2 deputies, Paetzel, I don't know how you pronounce that, and Primer. Now, Primer, as I understand, he was a deputy. He got fired for lying, from what I understand. That's alleged in here. Unrelated lying, but he exited the cruiser and walked unannounced into my client's home through a closed but unlocked front door. They didn't knock and announce their presence. My client was surprised to see 2 police officers just walk inside his house. Unbeknownst to him, his wife was outside in the backseat of the police cruiser, and they were there to serve DVPO protective order paperwork. He didn't know that at the time. Those 2 police officers walked in his house. They did not tell him why they were there, what their purpose was, but they began to approach him. It was dark in the house. They shined flashlights in his face. He had never seen the 2 officers before, and he got immediately afraid. They didn't appear to be acting like police officers. They didn't identify themselves. I mean, it was clear they were police officers, but they didn't identify the reason they entered his home. They didn't serve paperwork on him. They didn't tell him that why they were there at all. They just continued to approach him, and this is kind of scary. They continued to approach him with an aggressive and threatening demeanor. And so what do you do in that situation? He became fearful for his physical safety, and he asked them to leave. In no time did the officer serve or even attempt to serve the protective order paperwork. So they just approached him. He continued to feel aggressive. He started backing up, raising his hands so that they were visible, demonstrating that he wasn't a threat to their physical safety. The area was dark. The one deputy, Paetzel, was holding a heavy Maglite style flashlight, and who uses those anymore? They're obsolete. I guess they're heavy. You could hit someone with it. He's shining it in my client's face. He's blinding him. And it just further escalated his fear that he was in imminent danger. He's in his own house. As far as he knew, he didn't commit any crime. He didn't know why they were there. They walk in, didn't say anything about a warrant, anything. Imagine you're in that situation. Then suddenly, without any warning or any provocation from him, one of the officers, Paetzel, or however you pronounce that, all of a sudden violently struck my client in the face with his Maglite, striking him near his eye, causing immediate and severe damage to his face, excruciating sharp pain. So what do you do in that situation? He hadn't threatened the officers. He hadn't attempted to flee from them. He didn't know why they were there. He just saw them in his house and he asked them to leave. He didn't engage in any physical actions which would indicate that he posed a threat to them. So what do you do? Police officers come in your house. One of them hits you in the face with a mag light. Then the other officer joins in and begins to violently attack you. So it's sort of a self-defense situation. I get asked this question a lot. Well, what happens? I mean, can you defend yourself against an unlawful arrest? This was a self-defense situation. He's in a reasonable apprehension of serious bodily injury or death. They struck him in the head, unprovoked, unnecessarily, with a flashlight being used as a blunt weapon, with intention to cause great bodily harm or death. His first instincts were to attempt to flee the violence. So he ran into his hallway, tried to avoid another strike to the head, which a lot of times can be considered deadly force. The two officers pursued the plaintiff into the hallway, and they continued to attack him. The other officer struck him in the head with a closed fist. He punched him, basically. The one who struck him first, he began to attempt to strike him again with his flashlight in the head. Acting in self-defense, what did he do? My client, Dallas Conley, wrestled the flashlight away from the officer trying to hit him with it in the head, and then he used it in self-defense, hit both officers. As they were violently attacking him, hit him with his own flashlight. But he only utilized the amount of force necessary to be able to extricate himself from that situation, from that danger. He thought his life was in danger. So they attacked him with a flashlight. He took it from him, and he hit them both with the flashlight. And after breaking free, he drops the flashlight on the ground, and he runs out of the house. He's in fear of his life if they caught up to him. At this point, he's still unaware that why they were there. He hadn't been served with a protective order. They didn't have a warrant. In fact, he wouldn't find out about the real reason they were there until later on at his preliminary hearing. At the time, it was just like, all right, two cops walked in my house and attempted to kill me or seriously injure me. So he runs out of the house. He drops the flashlight in the house, runs out of the house into the woods. He believes that he'd be seriously killed or injured if these two guys caught up to him or any other buddies caught up to him. So he's hiding in the woods. This goes on. He tries to arrange to turn himself in to his parole officer. He was on parole. He trusted this guy. His parole officer, this was a Friday. His parole officer says, well, just wait till Monday morning to turn yourself in. It's a Friday. I'm a government employee. I got important stuff to do. Plaintiff's mom is worried. She's able to get in contact with a U.S. Marshal, and the U.S. Marshal arranged for him to turn himself in at the federal courthouse in Beckley, West Virginia. That's Raleigh County. It's, 30 minutes away or so, but it's in a different jurisdiction. So he was willing to do that, felt safe. So the authorities were notified that he'd be turning himself in, and the federal authorities were, from my understanding here, waiting at the federal courthouse, the next county over, for him to show up. That's all he wanted. So he goes back and he gets his pickup truck, and apparently the cops had flattened the tires. So he drove to a gas station, filled his air with tires. He calls his mom and lets her know that he's on his way to the courthouse to turn himself in. So then the mom calls the authorities again and tells them, all right, he's en route to the courthouse, the next county over. So his wife is then going to meet him there to pick up the truck when he turns himself in so that she can drive the truck home. But he never makes it home. That's the second part of the story. So while on his way to the federal courthouse, this is now April 5th, several police cruisers pull in behind him and began to follow him. He immediately realizes that someone had notified local law enforcement of the fact that he was en route to the federal courthouse. At that time, he thought these cops were going to kill him, just those local cops, not cops in general. And he panicked. He believed that those guys were there. They were still trying to kill him. And he made the, in hindsight, poor decision to flee. Fearing for his life, he fled from the police. And this is a crazy case. Fled from the police car, eventually crashing his truck, still within the same county. Now, there was eyewitness testimony from a witness at the preliminary hearing, and the subsequent criminal charges. The official police report says that the client got out of the truck, but the eyewitness, or two eyewitnesses from my understanding, one was just a Joe Blow who's driving somewhere near there and stops with a commotion, but also I think a state trooper had testified to this from my understanding, that these are John Does. I don't even know their names yet, but they caught up to him after the crash and literally pulled him out of the truck and basically viciously beat him after that. And like if you run from the cops, that you're going to have a bad mugshot generally, and in my experience, when they catch up to you. Now, this case was even worse, and I understand the fear because all they had was the first two guys, their side of the story. It's not like they had his side of the story yet, that they just walked in his house and hit him in the head with a flashlight. The story is that there was this brutal, vicious attack on the two police officers. So the colleagues, I mean, they're looking for this guy and they want to catch up to him even before he gets out of their jurisdiction. So they catch up to him, and in the paperwork, they beat him unconscious, as our allegations, unnecessarily, just to retaliate against him for the 2 days earlier, and probably also for running. But he's beaten unconscious. But the official police report, this is what's said. All right, he crashed his truck, then he got out of his truck and he slammed his face into a guardrail. Basically, that's what they said. All right, he slammed his own face into a guardrail. Had nothing to do with the 4 or 5 police officers that were beating the hell out of him. So he's taken to the local hospital, escorted by law enforcement. I've got the medical records, diagnosed with severe trauma to his head and face, fractured nose, multiple fractures of his orbital socket, lacerations, missing teeth, severe swelling of his face, including his eyes swollen shut. All right, and I actually have some pictures I can show you. All right, let me see if I can share this. All right, there we go. That's a picture of him after he was taken into custody. That is a screen grab from a surveillance video of when he's walked into basically the processing center. And you can see that he's got substantial trauma to his face, ripped shirt, blood all over him. He looks pretty bad. And I got the call pretty quickly that this had happened. And so I actually went and met with him at the jail because I didn't know that. It seemed to me that the evidence needed to be preserved of what he looked like. And I don't recall that the mugshot actually turned up. There was something screwy with the mugshot. So I went and visited him in jail. And I took a video of him. They wouldn't let me bring my phone into the jail. And this is Southern Regional Jail. So I'm the lawyer coming in to visit him, and they won't let me bring my phone in there, which I was going to use to take pictures. So they were giving me no way to take pictures of him. So what did I do? Well, I had to improvise. So I had my laptop, of course, I had to use to write with, but it had a camera on it, right? So I used that to document actually what he looked like in the jail. So here's me meeting with him. All right, that's me. This is in one of the lawyer meeting rooms at Southern Regional Jail. So that's still him days later. And I just sort of wanted to document what he looked like days later. I mean, he had teeth busted out. He had to have oral surgery to replace his missing teeth. He had multiple orbital fractures in his eyes in different areas. And he lost vision in one of his eyes. I may have been the one that he was hit with a flashlight with first. But he had substantial and severe facial trauma. And so that was pretty interesting that there was going to be no way to document it until I went and visited him in jail. But yeah, they beat the hell out of him. And I have no doubt it's like if you do something, even if it's not true, to a police officer, like they when they catch up, you don't want them to catch up to you. And it's how can you blame him for not, he wanted to get out of Mercer County and get to Raleigh County and get with the feds and turn himself in. I mean, he wasn't going to live in the woods for the rest of his life. He wanted to get to law enforcement officers that were uninvolved in the incident hitting him in the face inside his home. He wanted to get to the feds. And so they were waiting for him. It was arranged, but he wasn't going to make it because they found out that he was on his way and they stopped him. They got him before he could get there. And that's the result. Yeah, that's the result of him hitting himself. I'll play it again here. That's the result of you know what it looks like. And since I'm playing word games today, they don't care about this because they hate cops, I'm sure. But this is what it looks like if you were to just theoretically walk up to a guardrail and just smash your face into a guardrail. Not that's a good-looking guy there, but this is what it would look like if you smashed your own face into a guardrail. And I don't want to violate any World Health Organization standards here, so I don't want to give any false information, but I mean, you got to do a hell of a job of headbutting a guardrail to do all that damage in one headbutt. I mean, that is a quality headbutt job. And I've done quite a bit of headbutting. I mean, again, I was a high school and college football player, Division I football. I was a bouncer. I worked as a bouncer at some bad spots in Orlando while I was playing football. I was a bouncer at like a 3-story nightclub called Cairo in downtown Orlando. I was involved in some headbutting, and I know a good headbutt when I see one. That was a high quality headbutt. So back to the lawsuit here, because I know people are much more interested in excessive force cases and police beating cases than they are about medical issues. See, just for the comments, you guys are going to get me in trouble. Red tape, I can't answer that question. These are all buzzwords that are going to get me in trouble. Freedom isn't free. This time the mugshot camera malfunctioned too. No body cam footage, or did they malfunction? No, there was no body cam footage, and I don't know whether they had any body cams at that time. And I just talked to somebody today who had a police beating situation. I think it was the same county, may not have been, I don't recall. And again, this is sponsored by Proper Number 12. And we want to thank Conor McGregor for sponsoring this health information, and also the WHO. But I talked to somebody today who had a beating sort of situation, and actually during the incident, they took him somewhere where there was no cameras. Not the same agency though. It's not the same guys. Took him somewhere and said, well, this is going to be on your body cam. You can't get away with this. And they said, here, look at this. Look at my chest. And you know what was on his chest? An empty hole where the body cam was like 5 minutes ago before he took it out. They took their body cams out, according to the allegations. So you can do a FOIA request and we'll see if there's any body cam, but I doubt it. There never is any body cam in West Virginia. Those are other states where there are rules that are followed like that. But again, that's like also systematic racism that exists in other states. So we don't have that here. Looks like a raccoon with cavity. Oh my God, that's funny. I mean, it's not funny. I mean, he was in bad shape, and that's what happens to you. I mean, you fight the police, or they think you fought the police, or you hit some of their buddies, or did something worse. I mean, you don't want them to catch you, and everybody knows that. I mean, people know that. People know that. Back to the lawsuit here. Okay, so again, this is 1983 case, federal court, Southern District of West Virginia. but yeah, and that's what I was talking about. Fractured nose, multiple fractures of his orbital socket, missing teeth, severe swelling of the face, eyes swollen shut. Underwent a long process of recovery, including dental surgery to repair multiple missing teeth, knocked out by the officers. Period of time, he completely lost vision, one of his eyes, suffered from migraine headaches, severe jaw pain and eye pain. And as I get older, now in my 40s, hell, I get that stuff anyways. My eyes hurt. My eyes stop working right. I get headaches. My jaw hurts. But, I mean, this is taking it to another level. And he was young. So he still today suffers from a lot of these injuries. Of course, like a lot of people, and regular people in rural West Virginia, or men anyways. Usually women have some sort of government-provided health insurance because they got kids. But men generally, most of the time, don't. So he wasn't able to get, surgeries he may have needed necessarily. But he did get his teeth fixed, I believe, which was expensive. And there was a trooper. Well, before I get to that, one of the original cops that we know his name, from my understanding, was later terminated from the sheriff's department for making false statements while serving as a police officer, but it was unrelated to my understanding from this case. So anybody, had other incidents or knows something about either of these guys, let me know. There was a state trooper who testified, and I didn't handling the criminal case. Usually that is a conflict of interest. There was a criminal defense lawyer who I have a lot of faith in. He's a really good lawyer there in Mercer County, West Virginia, named Joe Harvey. He's been handling this case. But this state trooper testified, apparently. So I'm told at the preliminary hearing, and he testified that he observed these John Doe sheriff's deputies beating my client. So we'll see if that pans out. Subsequently, he's indicted on every charge that they could think of, trying to, absolutely hammer him. Fast forward 2 years later, and that's still going on. He ends up getting out on home incarceration and really does such a great job. The judge lets him off of home incarceration, and he goes about his life. And he was working at this time, and he was a contributing member of society, and he's been so afterwards. But he's obviously had this hanging over his head for the past 2 years. So this is a civil lawsuit. This is for money to get him compensated, but he still has the underlying criminal charges hanging over his head. And of course that can affect the civil case. So you always want to, if possible, deal with the criminal case before you get to the civil case. Sometimes that's not possible. For instance, here, if you're coming up on the statute of limitations and the criminal case is still out there, then you got to just go ahead and file, which is what I did. So here are the claims here. If you're interested in the technicalities of how this works, count one, use of excessive force violates the Fourth Amendment. So Fourth Amendment is not just search and seizure. It's also excessive force. It's technically an unreasonable seizure when the police beat you. So it's a Fourth Amendment violation. It gets more complicated. Once you're in handcuffs in the police car or the processing center, instead of the Fourth Amendment, it then goes to the 14th Amendment. It doesn't really matter at this point, but it becomes a little more difficult to prove. You're called a pretrial detainee at that point. For prisoners who've been convicted, they're in prison. That falls under the 8th Amendment as far as excessive force allegations, and that's just force that rises to the level of cruel and unusual punishment. But that's, again, a different video. This is a basic Fourth Amendment excessive force violation. And if you're interested in how you allege these things, you have to use a lot of specific detail. You can check it out. I'll here in the next day or so, I'll put it up on the website. Again, thecivilrightslawyer.com. But right now there's important health information up there for you to know. So you go through all of you want to avoid a motion to dismiss. So you got to allege it properly. That's why people who want to file civil rights claims, you got to go to a lawyer that knows what they're doing, that handles these types of cases, because it's not like a car wreck case. You don't want to just go to like the regular car wreck lawyer, because they do the opposite. They allege as few facts as possible, because it's state court, you're allowed to do that. And you want to be as vague as possible, because when the client testifies, who knows what he's going to say. Federal court, you got to be very specific. So I even cite case law in here. And then I go through why they shouldn't be given qualified immunity. And we went through all of that. So count 2 is basically the same thing, but that's for the second incident of where he threw his face into the guardrail. That's count 2, just another Fourth Amendment excessive force case. It's still under the Fourth Amendment. And same thing, you just have to allege very specifically. Now, count 3, you may not know this, bystander liability. So what do you do if, say, there's 5 or 6 different police officers involved in a beating situation, or at least those are the allegations, and you don't necessarily know who threw what punch, who kicked what kick, or maybe who didn't do any of it, but just sort of watched. Well, there's a mechanism in the case law for this. It's called the doctrine of bystander liability. So you might have heard that the cops don't have to protect you, that they don't have any duty to protect you from criminals, etc. Well, there are exceptions to that. There's case law that says that, but there are exceptions. One of which is the doctrine of bystander liability. So that means that if there's a police officer who's present while you're getting beaten by other police officers, an obvious civil rights violation, an obvious deprivation of constitutional rights, federally protected rights, they then have a duty to stop that, to save, to protect and serve at that point. They have to protect and serve you, and not in the sarcastic sense. If they don't do so, then they can be held liable, just like the other 4 or 5 that actually did the beating, and that is under the doctrine of bystander liability. So if it would be readily apparent to an objectively reasonable officer that this harm is occurring, and if they didn't do so, then they can be liable. Here's the wording, actually, but who took no actions to stop it. So, I mean, it's pretty easy to prove. If there's a beating took place, this guy was there. It doesn't matter whether he didn't throw any punches, if he did nothing to stop it. Now, there are some arguments about that might not apply to all civil rights violations. I've actually had it used in excessive force situations. I've had it go to juries, but I've also had it argued with other types of violations, such as unreasonable searches and seizures, like warrantless search, that it's not the same. It shouldn't be applied in those cases. So the defense lawyers had some sort of argument that it's not supposed to apply in those cases. So it could go either way on those, but it's definitely meant for the excessive force violation sort of thing. So that is I'll call that the Conley case that we had just filed in federal court based out of Mercer County, West Virginia. So that, I think, will be an interesting one to follow, because it was in the news when this first happened, but you'd never heard his side of the story, because you had these serious felony criminal charges against him, and he's not testifying yet at that point. So you just hear like the police officer side of the story. But like I said, there was a state trooper who supposedly witnessed and testified to some of the excessive force on the second incident, and also just a literal bystander witness who says that he saw him taken out of the truck, etc. So we'll see how that actually pans out, but it could be an interesting case to follow. And that's been sort of my bread and butter is excessive force cases. And the reason for that is qualified immunity, because it's very rare that police officers get qualified immunity for a police beating situation, because it's very clearly established. There's no ignorance of the law excuse for beating somebody unnecessarily, or for even watching it happen. They tend to give qualified immunity in like technical search and seizure violations sort of cases that are, good faith mistakes, things like that, but not in like, and everybody knows that this is wrong to, punch somebody in the nuts who's handcuffed just because they, told you to shove your badge up your rear end. Those are factual disputes, which the police officer in question is not going to admit. He's going to deny it generally. And so what do you do when you have a disagreement of what the facts are? You have a trial and you have a jury. So qualified immunity is rarely an issue. That means they're much more likely to be settled, because even if you don't have a great chance of winning, it's still going to cost them a lot of money and attorney fees to defend all the way through trial. And under Section 1983, the whole point of these cases is if the plaintiff wins, even if a jury awards $1, you get your attorney's fees, your reasonable attorney fees, which could be 6 figures. So that's why it's worth it to fight these cases. Underground auditor. It's a wonder they didn't give me a cavity search when I left that jail. Well, I don't know. There's no way they could have searched it and found it. I mean, by the time I took that video, it was in my laptop. It was password protected, and they could have done whatever they wanted to me or to my laptop. Well, I guess, it's not like it was on Wi-Fi, so they could have destroyed my laptop and destroyed the video. But it turns out, like I showed you, there's other surveillance footage that did survive that shows him walking into the processing center. And he actually, he except for the blood, he looks worse like days later. And that's kind of common with swelling and the black eyes. Like it'll get worse and worse as time goes on. And originally it might not even look as bad, but 12 hours later, they really are in bad shape. Mark Miller, handcuffed, then beat. No, see, it was 2 different dates. April 3rd is when they just walked into his house. And that's why the criminal case is so tough and it's still out there. Because the cops came in his house and he ended up hitting them both with a flashlight, their own flashlight, and then fleeing the house. Now, the news media just reported those 2 cops' side of the story, which was, we were just there to serve, domestic violence protective order paperwork, and we were violently attacked by this, domestic abuser. But his side of the story is that, he was just in his house, and these guys didn't even knock, just walked in the door. He asked them to leave. They wouldn't leave. They approached him, and one hit him in the freaking face with a mag light. So if that's true, then I think there's a great case to be made that, everybody has the right to defend themselves against somebody trying to kill them. If they didn't, he wasn't under arrest at that time. He wasn't, far as I know, there was no probable cause to believe that he could have been under arrest, that he had committed any crime. They were just there to serve civil paperwork. And there was no allegation that they did, in fact, serve that paperwork. So they walked into his house and hit him in the head. So what do you do? I don't know. That's an interesting situation. And it's probably something that's just got to be tried to a jury. But that's, it helps that one of those 2 cops was later fired for lying. So, what does that harm if you lie? Your credibility. And the wife was actually there in the back seat of the police cruiser and witnessed everything through the bay window. So she's able to testify that, corroborate what his story is. So that really just leaves, the one cop who hit him with the flashlight, he said, she said sort of thing. But like I said, there's a she and a he on the other side of that. Now that's the first one. And then there's the second one. And I don't believe he was handcuffed at the point that they were beating him. At that point, they had just pulled him out of the car and our allegations are just sort of beat the hell out of him at that point. I don't think they bothered to handcuff him. I mean, he just sort of, he was just wrecked his truck and, they pulled him out. I don't think he was fighting him or anything. They were just, that was the beating he was always going to take when they caught him. And I mean, that's our allegations anyways. And they had no need to handcuff him. I mean, 4 or 5 cops. I mean, a lot of these, I don't know how big these guys were. I don't know their names yet. But so, I mean, they're just John Does at this point because again, the criminal case is ongoing. The indictment doesn't mention the names of the people involved. It should. So that's not known to me yet. But they had no need to handcuff him. So he wasn't handcuffed, but he didn't need to be handcuffed. I mean, 4 or 5 on one, somebody who's not even resisting you. Is he a known and violent felon? No. I don't know he had a parole officer at the time. So I don't know. He obviously had some criminal history. I don't recall what specifically it was or whether it had anything to do with violence. But see, what they would say, I speculate, is that the 2 cops from the 2 days earlier or a day and a half earlier, they claim that he just violently attacked them inside his house. So yeah, they have, the belief that he has the capability of doing violence to the police. So absolutely, they do have that information, that knowledge going for them. So I mean, that's probably about the same as being a known violent felon, even if it's not true. So it doesn't have to be true. It's what they were presented with. Now we'll see whether or not that was reasonable based on what their testimony is or what they really knew. Red tape. Yeah, I mean, that's right. Your constitutional rights aren't benched because of previous convictions. That's true. And that's not what I said. The test for excessive force, there's really, under the Fourth Amendment, there's a 3-part test. They're called the Graham factors. And that's established by the Supreme Court, Graham versus Connor. And there's 3 things that the trial judges they're directed by the Supreme Court of the United States to consider. One is the severity of the crime that the guy is suspected of committing. Secondly, whether or not he's actively, well, maybe I'm confusing these, whether he's actively resisting arrest or attempting to evade. And thirdly, whether or not he, damn, you're catching me on the spot here. Whether or not he, let's see, whether or not he, whether or not he's evading or resisting arrest, what the crime he's charged with, and God, what's the third one? Graham factors. All right, now I got to pull this up. I'm having a senior moment here. Let me pull out the trusty excessive force case law. Basically, the analysis is whether or not an objectively reasonable officer, with the information that they're presented, whether or not the person posed a threat of harm to himself or others. So the Graham factors. 1, what is the crime? Why are they chasing the guy? Why are they trying to arrest him? Is it for public intoxication or trespassing or something that's very minor? Or is it because he's wanted for murder or beating police officers, feloniously beating police officers? And then lastly, whether or not there's any indication that either the officers or some other individual was in immediate risk of harm. So that's where your question comes in, or that's where that comes in, because if somebody, like Daniel's question, is if the cops know that are involved in the use of force, if they know that this guy has 3 convictions for battery on a police officer, and that they know that they have somebody who's capable of committing violence or being a threat to them, of committing violence or being a threat to them. I'm not saying it doesn't matter if it's true. They just have to articulate or prove that they had this knowledge, that he had the convictions, or that even if he was charged with it before. So it will come in as relevant evidence. It's up to the jury to weigh whether or not it's reasonable. But previous convictions that have to do with violence, fighting with anybody, especially a police officer, will come in at trial for that 1 Graham factor that has to do with weighing the reasonableness of the officer's decision of what kind of force he was going to use based on what he knew about the subject. So if criminal history has to do with violence, it could come in. I'm not saying it should come in. That's just how these things are evaluated for reasonableness. Yeah, Indie Oscars. I know the first video was taken down. I'm not sure if it's still up on YouTube. Lulu, is there body cam footage of the alleged attack on the officers? No, there's no body cam footage. We have to take the officer's word for it, one of whom was fired for lying. That leaves my client and also his wife, who was watching from the police car. And also other evidence, such as, the trauma to his face, or the lack of trauma or trauma to the police officers, whatever injuries they documented or didn't document. Of course, he admits to hitting them to try to extricate himself from the danger. It's definitely not a black and white case of, police officers stopping the police car and getting a handcuffed subject out of the back car and just beating the hell out of him for running his mouth or something like that. I mean, it's definitely a more complicated case than that. And, that's why they build courthouses, right? That's why we have jury trials. Good question, Javier. How about the issue with the warrantless entry and them not serving him any documents? So I seriously considered another count in that lawsuit for another Fourth Amendment violation for the warrantless entry into the house, for an unreasonable search and seizure. And I went back and forth on it. I thought about it. I researched it. And here's the conclusion I came to, is that primarily this was an excessive force case. And I think that's going to be enough to get it to a trial. And we could have made a claim for unreasonable search and seizure, but here's the problem. There was DVPO, Emergency Domestic Violence Protective Order paperwork that was to be served, even though it wasn't served. So in that paperwork, they're going to be able to prove that the wife had consented to their entry into the home, because that's what that paperwork says is, you're consenting to going in my home to serve my husband or my boyfriend that lives with me this paperwork. So there's consent. Now, just because they have consent to enter from one of the residents of the house, that doesn't mean that if the other resident is present and objecting, that they can still enter without a warrant. And that's the case of, that's what the law is. So now my client, Dallas, was present. He saw the cops come in his house, and he objected. He refused consent. He asked them to leave his house. So even though the wife gave them permission, technically, as per the documentation, he asked them to leave. So that defeats her consent, because a co-tenant of a home who's present and objecting, that will defeat the consent of the other co-tenant or the spouse. However, they still would have a great way around that. And that would derail, I think, the litigation, which is unnecessary. I mean, it's about excessive force. It's not about the technical search and seizure violation. And here's how they'd get around that. Exigent circumstances. I don't know if I mentioned it, but there also was a small child that was in the home, a very young child that was in the bedroom next door. Now, I don't believe the DVPO applied to the child. It was just for the wife, best as I can tell, with paperwork that is difficult to get. It was just for the wife, I believe, but it would be enough, in my opinion, and I know how these things go, that they would be able to claim that there was some concern. The child was in the house. They had some concern about the child, about whether or not the child was safe, and that's going to be enough to excuse their presence in his house for exigent circumstances. And I don't agree with that. I think it's possible one could win that argument, but again, unnecessary where we have a beating to this extent on two different occasions. So it's primarily an excessive force case. I do think it also is relevant to the excessive force case, the first one, because it goes into the reasonableness or unreasonableness of their actions, I would argue, because they don't have a warrant. He asked them to leave, and yet they still continue to approach him and eventually hit him in the face with a flashlight. So the fact that they don't have a warrant, they don't have permission to be on the property, that is usually dispositive of the Fourth Amendment search and seizure issue, except for any possible claim of exigent circumstances, an emergency. They're worried about the child that is somewhere in the house, and especially because the subject is acting erratically, whatever, blah, 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 they'd come up with. So that's what would happen there. And yeah, we could litigate that, but I think it would be a distraction. No documentation supporting a warrantless entry for child safety. Well, they had documentation for a warrantless entry to serve the DVPO paperwork for the wife, but the fact that my client said, get out of here, leave my house, that negates that consent from the paperwork. And then they would have to rely on exigent circumstances. And all they have to do is articulate some concern of, that there's some emergency, potential danger to a child in the house. I mean, I'm not saying that it would be successful, but I have a feeling, having done this a bunch of times, that if you have an exigency, as I talked about, like in the first video that got censored and the first part of this video, we all want to keep kids safe. So it's if any exigency is enough, it's some concern about a child, even if it's just BS that their lawyer told them to say after the fact. Must police serve papers up front, or can they take their time? That's a good question. I mean, if they're just there to serve paperwork, then I would argue yes. I mean, they obviously should say we're here to serve paperwork. I mean, I think it goes into the reasonableness or unreasonableness of what they did, and we'll see what their testimony is. Did he resist being detained? Well, in the first instance, the first thing that happened was they hit him. According to our allegations, I'm sure they have a contrary point of view, that he was hit in the head with a flashlight. So at that point, he was seized by them, to say the least. So he didn't have any opportunity to resist that. After that, yeah, he did engage in self-defense or self-preservation, which he thought was necessary, and he thought he was going to die at the time. Now, the second time, if that's what you're asking about, it's my understanding that he gave no resistance, that they pulled him out of the car and beat on him, and that he wasn't fighting them. And I think there's eyewitness testimony to that. Now, what was he resisting? Was he not resisting? What is resisting? There's a lot of case law on that. There's passive resisting, and then there's fighting with the police. So even passive resisting, like allegedly not allowing yourself to be handcuffed or to be taken a certain direction, doesn't necessarily justify very much violence according to the case law. But we'll see what the testimony ends up being. Red tape. If they're worried about the child or the wife, radio communications should collaborate that claim. Yeah, I don't. As far as I know, there's not going to be any radio communications to collaborate a claim that there was any mention of the child. And I don't think my client recalls any mention of the child whatsoever, that the child was never ever in danger. I just anticipate it, because that's what their lawyers are that's what's going to be said after they are lawyered up. At least in my experience. But who knows? Maybe not. Maybe we could, if they don't, maybe we amend the complaint. But it doesn't matter. I mean, we've got the excessive force claims. Char, 4 to 5 cops could have taken him down easily. I mean, absolutely. And the number of police officers, and I don't know what the exact number is. It may be 4 or 5. It may only be 3. I mean, you never know the way things turn out. But that all goes into reasonableness. There are cases that say one big cop and one small woman already is enough to prove excessive force if you have a substantial violence there, because it's a mismatch, as we would call in football. I mean, it's laughable. So that all plays into the reasonableness standard. Hey, Rowan, how you doing? Let's see. Who else do we have here? Do you have witness accounts? Yeah, at the first incident, the wife was a witness. Now they are still married, so I'm sure that will be downplayed by the defense. And at the second, there was a state trooper who was a witness, and there was also just a random guy. And interesting side story. Apparently, I'm told that law enforcement tracked down the witness, this random guy afterwards, and tried to get him to say that the defense lawyer basically put him up to this. So very, very scary story. We'll see if that actually actually pans out as true or not. So hopefully this witness hasn't been scared into submission. Does the department wear body cams? I think they do have body cams now, but this happened like 2 years ago, and I don't believe they had them on. Did he have cameras in his house? No, unfortunately not. Does the fact that he was en route to turn himself to federal authorities but was stopped count for his defense? Well, it depends what the defense is for. If you're talking about the criminal charges, I mean, he's charged with attacking the 2 police officers in his home at the first incident, so that doesn't pertain to that. I don't recall if they charged him with like a battery on the officers in the second incident, which would be laughable with like 4 or 5 officers, but they charged him with like felony fleeing and all this stuff. So would it pertain to the fleeing? I think so. I mean, in the end, it could always pertain to jury nullification. I mean, if you can convince the jury that, yeah, I fled, but I fled because I felt that I was in fear for my life. Maybe that's not even an actual defense, but it certainly would pertain to jury nullification. Does he have any military training or martial arts training that we deem him as a threat? No, I don't think so. He has no training in Rex Kwando. All right. It's because of the first video that was tenderly loved by our committee chairman at Big Tech and with the government. I'm running a little bit over, so I definitely need to get home by now. But I appreciate you guys watching. I'll do some more about this case when I have, I've got some more surveillance footage. I could go over. So I'll definitely do more updates on this case as it goes on. I think it's an interesting case factually, and we'll see also what happens with the criminal case as well. And regarding the other thing, again, make sure the whole point of this video was to go and check out some child safety information at civilrightslawyer.com. So make sure you're following WHO standards. So other than that, again, make sure you check out, if you want children to be safe, if you like children at all, go there and make sure you read that important safety information. And WHO is wonderful. Dr. Fauci is an honorable man. I really appreciate you watching. And if I don't post anything else, which I may, I will see you hopefully next Monday. If dear leader gracefully or graciously allows me to communicate again about my love for the WHO and child safety and the government, I'll see you on Monday. So thanks for watching.